The Weinstein retrial sheds a revealing light on Judge Subramanian's relative inexperience in the Diddy trial, especially when comparing how judicial discretion, evidentiary balance, and jury integrity were handled. Here's what it suggests. 1. Lack of assertive judicial control. In the Weinstein retrial, Judge Curtis Farber acted swiftly when the jury showed signs of tension and intimidation, declaring a mistrial on that count to protect the integrity of the proceedings. In contrast, Judge Subramanian has been widely criticized for allowing emotionally charged, prejudicial testimony to persist in the Diddy trial, without clearly establishing probative value or shielding the jury per Federal Rule of Evidence 403. 2. Weak gatekeeping of evidence. Weinstein's earlier convictions were overturned due to improper admission of uncharged, prejudicial prior bad acts, a lesson the judiciary took seriously going into his retrial. Yet in the Diddy case, Judge Subramanian has allowed a stream of non-criminal, consensual, or temporally distant behavior to be admitted, often without clear linkage to RICO predicates or enterprise structure. This shows either a gap in his command of criminal trial evidence standards or a passive judicial temperament unwilling to challenge overreach by federal prosecutors. 3. Experience matters, especially in high-profile cases. Judge Farber, a veteran of many criminal trials, demonstrated the balance between public interest and procedural fairness. Judge Subramanian, appointed in 2022, is still relatively green in managing complex, media-saturated, high-stakes federal criminal trials. His lack of visible pushback to prosecutorial overreach in the Diddy trial implies a need for deeper understanding or stronger backbone when upholding criminal procedure. Conclusion: Judge Subramanian's handling of the Diddy trial, when contrasted with the measured judicial oversight in the Weinstein retrial, raises valid concerns about his experience navigating Rule 403 violations, his role in insulating the jury from spectacle, and his preparedness for appellate scrutiny. It doesn't mean he's biased, but it may mean he's not battle-tested enough to manage the prosecutorial power plays occurring in real time. Is this part of the reason the federal government wins 98.9% of its cases? When judges with little to no experience in criminal trials are placed over high-profile prosecutions like the Diddy case, it raises serious concerns about impartiality, preparedness, and the ability to critically challenge prosecutorial overreach. This isn't just about inexperience. It suggests a systemic bias, where the deck is quietly stacked in favor of the prosecution by assigning judges who are less likely to scrutinize or interrupt the government's strategy. Is this oversight, or is it by design?